Hi, Nan Jensen here. I'm back in Denmark, as you can see from the white wall behind me. And this video is going to be about wills. Before I start, I need to do my disclaimer. These videos are legal information, not legal advice. If you need legal advice, you need to contact a lawyer. You need to tell them your whole situation, and you need to get a letter of engagement from them. So don't rely on anything you hear in these videos, it's just general information. Okay, so the topic today is wills, and I'm going to give you 3 reasons why you might want to make a will or might not want to make a will. Then I'll say a little bit about some considerations that a disabled person may want to have if they're thinking of making a will. But I will also be making a video specifically for people with cognitive disabilities, so some of that information will cross over. And finally, I'll talk about some considerations that family members should have when they're thinking about making wills. And some of that information is also going to cross over into the trust video, which will be the next one I'm going to prepare, and I hope I'll get that done pretty soon. I know I've been on a bit of a holiday. So let's start by talking about 3 reasons to make a will or not make a will. The first one has to do with testamentary guardians. So testamentary guardians are people that you appoint to take over the guardianship role for minor children if there are no guardians left alive after you die. So if you remember in the video about guardianship, I can't remember what number that was. This one is number 8, by the way. The guardianship role is about making decisions about a minor, so an underage child under 18. And you can make a will that says who you want to take over the guardianship role. Now, if you are divorced, that doesn't mean that you can replace the surviving parent or any other surviving guardian. It's for the situation where there are no guardians left. And it is a decision-making role. It doesn't necessarily mean that the person or persons have to take on the residential or custodial role. It's about having that responsibility for guardianship decisions. That's the first thing. So even if you don't have a lot of assets, you might want to make a will simply to appoint testamentary guardian or guardians. The second reason why you may or may not want to make a will is to do with the size of your estate. So the Administration Act, which talks about the administration of estates, both with and without wills, has some provision for the ability for small amounts of money to be paid out without there being a probated will or an order for administration. So if you have a small estate and no complicated wishes about where that estate should go, then you may not need a will. But if you have complicated wishes, you don't want this traditional people to get your assets, or if you have a large amount of assets, then it's probably a good idea to make a will, or it is a good idea because, first of all, if you don't make your wishes known in a will, then nobody will know what you want, and the assets will be paid out to the usual people, which are normally your partner or your children or whoever is surviving. But the other thing is that it can be more complicated and more costly for your family if you do die without a will. Now, the Administration Act specifies in Section 77 who gets your stuff if you die without a will, and it provides for someone to apply to administer the estate. So even if you haven't appointed an executor and made a will, then someone in your family can still apply to be the administrator and distribute the assets according to Section 77. So if you don't like what it says in Section 77, then you probably need a will, whether you have a small estate or a large estate. The main thing with a large estate is that if you haven't made a will, then it is more complicated and more costly for your family. So it's a good idea to save them the time, even if you are going roughly by what the Section 77 says. I'm not going to tell you exactly what it says because it lists a large number of scenarios. You can look it up online. And it explains what happens to the assets if someone dies without a will. So, for example, if you die and you only leave your parents behind, then the parents get your assets. And if you die and you only leave a partner behind, then the partner gets your assets. If you live a partner and children, then that's a bit more complicated, and there's a whole formula for that. I won't go into the details here. Again, you can look it up online, or you can go to one of our workshops to learn more about that. So that was the second reason why you might or might not want to make a will, or second consideration. The third one, the third one was actually about the Administration Act, so I combined those two, sorry. And the third one is then if you don't like what's in the Administration Act. So if you do want to give your assets away in a different way than what's in there, then you may want to make a will. Having said that, it's really important to realize that people can apply to the court to have a will overturned or changed, and courts do it in certain situations. So you need to be careful if you are dying with assets, or if you expect to, that you make a will that it would be considered fair by the court. And it seems a bit ridiculous, I know, because if you die with no assets, then no one gets anything. But if you die with assets, then different people can make a claim against your will if they don't think that they've been treated fairly. I understand that it seems a bit ridiculous, but that's the law. So this is, again, I don't want to sound like I'm advertising for legal services or for lawyers to make money, but this is an area where people often try to save money by going around and trying to get the cheapest price, or by making a will themselves. And all I can say is that lawyers can help you avoid situations where later on there's going to be a problem. So if your will is unclear, or if there are people objecting to what you've done, then some of your assets could wind up being spent on legal fees, which really wasn't necessary if you had consulted a lawyer, because lawyers are there to try to help you avoid that situation, to try to help you formulate a will that's clear and that's fair, or to mitigate any unfairness that you might put into it, to avoid any risks of there being court action about your will afterwards. So those are the three reasons why you may or may not want to make a will, or three things you should consider. Now I'd just like to speak briefly to people with disabilities. When you are making a will, if you need a will, then it's really important that what is in the will has your wishes in it, and not wishes that other people have imposed on you, or that things that other people have told you to do. And I realize that for many disabled people, they're very used to taking advice and having other people tell them what to do or make decisions for them. I've probably been guilty of over-advising my own children, and I've met some disabled people who literally don't seem to have made any decisions for themselves, even up to the age of 40 or 50. It's really important. Also, for us as lawyers, we aren't allowed to let someone sign a document that they don't understand, and where they may have been under pressure. So it's really important that you find a lawyer who's going to take the time to listen to you, to talk to you, and to ensure that you've given your own wishes and not those of somebody else. My experience working with some disabled people has been that I talk to them, we make a plan for the will, and then they phone me and say, oh, no, I changed my mind. And then I go to see them again, and it turns out they changed their mind because their brother or sister or someone else who they trust has told them to do something different. Now, there's nothing wrong with that as long as they are sure that that's what they want. And that's the lawyer's job to be sure about. So if you have a lawyer who isn't really listening, or doesn't seem to be spending enough time with you, then you need to find a different lawyer. Or if they're not explaining to you what's in the will and just pressuring you to get it signed, that's another warning sign that really maybe you need someone different. Okay, so that's all I'm going to say in this video for disabled people. Now I want to address the family members who are making wills. This is really important if your family member is on a benefit, because at the moment there's both asset testing and income testing that goes on for disability benefits. And so if you aren't careful, you could be trying to assist your disabled family member and could wind up putting them at a disadvantage because you've tried to leave them a legacy, and instead of them being able to use those funds for extras or holidays, they wind up having to use it for ordinary day-to-day things because their benefit was cut. I'm not going to go into the details of what those thresholds are because these things change all the time. You need to check the WINS website. I would strongly suggest that before you make any big decision, you talk to WINS and try to find out what would happen in that particular situation. The problem is that WINS change their rules all the time. So really what you need to be doing again is working with a lawyer that understands these issues and that can help future-proof any situation, because obviously once you've died, it's too late to change the will, to update it according to whatever new rules have been put in place. So my view is that, and this is not meaning to take away disabled people's rights, but in order to protect them from predators and also from inadvertent problems with WINS, it's often best for disabled people not to have an awful lot of assets in their name, and that's where trusts can come in as something that can help with that. So we'll talk about that in the next video. But the idea is that when you're making a will, you need to think about whether your disabled person should inherit directly. And this isn't obviously just for parents and direct relatives, but if you have any older family members, such as grandparents, you may need to take a very difficult discussion and talk to them about what's in their will, because they may, without your knowledge, be planning to leave some money to your disabled person, and it may be a much better idea for them to leave it in trust or to leave it to a family trust that you have already set up. So these trusts things we will talk about more in the next video. I'll just say briefly here that a will you can make something called a will trust, which is where the will basically becomes a trust, and that's where you say that you direct that certain funds are held in trust for a person. It's not clear to me completely how WINS will look at this. I think it still could be problematic, so before you do something like that, you need to check with WINS about how they will consider it in terms of asset testing and income testing. I think that's about all I was going to say. I would just like to say a word about predators, because that's, or maybe I'll talk about that in the trust section. Just remembering that when there are a lot of predators out there looking to get our disabled family members' stuff, and our disabled family members can be very vulnerable to people who they think are their friends, and often the ones who are abusing them are close friends and family, or who are taking advantage of them. So there is financial abuse, and so one of the things that should be in your mind when you're making a will or planning for the future finances of your disabled family member is how those funds are going to be managed, and how are they going to be kept out of the hands of predators. Okay, thanks for listening, and I'll see you in the next video, number 9, which will be about trusts.